At common law, employees assumed the ordinary risks inherent in their profession and had no right of recovery against an employer for failing to protect against those risks. However, many states have statutorily modified or abolished the doctrine of assumption of risk for injuries sustained during the course of employment as a result of the negligence of employers. In Maddox v. City of New York, the New York Supreme Court Appellate Division considered whether a professional baseball player was within the protected class of individuals under New York statute requiring that employees be provided with a safe place to work. On June 13, 1975, Elliot Maddox was playing center field for the New York Yankees when they took on the Chicago White Sox during a night game. The Yankees were playing at Shea Stadium, which was owned by the City of New York and was the home field of the New York Mets, because Yankee Stadium was undergoing renovations. The game scheduled for the night before had been canceled due to bad weather and poor field conditions. In the ninth inning, Maddox chased down a fly ball in right center field. After catching the ball, and while in the process of throwing the ball into the infield, Maddox's right foot got stuck in a patch of mud or wet grass, and his knee buckled, causing him to sustain injuries. At the time, Maddox knew that portions of the field were wet. However, even though Maddox had told a grounds crew member of the wet conditions, he didn't request to sit the game out or have a replacement player. Subsequently, Maddox sued the City of New York and others in state Supreme Court, alleging in part that they were negligent in the ownership, maintenance, design, and construction of the stadium. Further, Maddox claimed that their negligence was the cause of his injuries. Following discovery, the City of New York and others moved for summary judgment based on assumption of risk and contributory negligence. The court denied the motions, concluding that Maddox was carrying out his assigned duties and that it was a question of fact whether he acted reasonably. The City of New York and others appealed to the New York Supreme Court Appellate Division.